Faced with the delays and the snowballing emotional and financial costs of family litigation, solicitors and clients are turning increasingly to non-court dispute resolution. Some issues can be resolved by agreement, facilitated by things like mediation, early neutral evaluation, or private FDRs. Others require a decision to be made by a neutral and experienced arbitrator. This video explains what arbitration is, the advantages of it, and what we in 3PB can offer in relation to it.
Arbitration is a direct alternative to court. Parties agree to be bound by the decision of an arbitrator, and they can choose that arbitrator. The arbitrator will be an expert in the family law that they are choosing.
If a party is dissatisfied with the arbitrator's decision, they can appeal to the family court. The family court would only allow the case to proceed if it considers that there are reasonable prospects of showing that the arbitrator's decision was wrong.
So one of the things you're going to be thinking about is who and how do you go about choosing an arbitrator. Really, the ideal situation is that the parties agree on who the arbitrator is going to be, but it's not the end of the world if they don't, because you can apply to IFLA and they will appoint an arbitrator for you. So it can be either way, it doesn't matter.
Turning to the types of cases that can be referred to arbitration, in children cases, all private law cases can be referred, save for a few identified exceptions. The exceptions are things like removal of a child to a non-Hague Convention country, or cases where there are significant safeguarding issues. Many people think that financial arbitration only extends to divorcing couples. Well, that's not correct. It also extends to cases under Tolata, the Inheritance Provision for Family and Dependents Act of 1975, to the Married Women's Property Act, and a number of other statutes.
Parties can choose anywhere to have the arbitration at a time and date that's convenient for them. The arbitration is entirely private and confidential. The court's transparency provisions don't apply. Changes to the family procedure rules in 2024 means that the courts actively encourage the parties to attend non-court dispute resolution, and there can be cost consequences if parties refuse to engage in the process. Arbitration is one of the methods of non-court dispute resolution.
It's like a court process, but it's much quicker. The parties can get their justice in a more timely fashion. They can go to an expert. The arbitrator will know about the issues. They'll know about the law. You can be confident in that, and they will be able to dedicate all the time they need. And whilst the arbitrator, you might have to pay for them, ultimately, you save money because you're not going through that lengthy court process, and people get justice quicker.
Overall, the parties retain a degree of autonomy throughout the process. They decide where arbitration takes place, when it takes place, what issues are determined, and they agree to be bound by the decision. The financial and, more importantly, the emotional cost to the parties will be reduced because arbitration is a quicker, less stressful and cheaper process.
You might be considering why 3PB? Well, we have an extensive group of lawyers who've been very experienced in this area of law, both through the courts and through arbitration. We are geographically all over the country, so that helps as well. We have our own centres where the arbitrations can take place. We're friendly and approachable, and we'd like to think that we are indeed anyway, and our rates are very reasonable. So all good reasons to come, but by all means shop around.